Jordan Phillips versus Katie Fletcher.
Court will note the appearance of Mr. Toth on behalf of the plaintiff, Ms. Henderson on behalf of the defendant. We have two motions before the court. The plaintiff's motion for specific parenting time for exchange location and school breaks, and defendant's motion for counseling. Mr. Toth, you want to proceed?
Yes, Your Honor. Your Honor, clearly the existing parenting time order is not specific as it relates to the items that we've included in this in our motion. I believe that we have kind of an agreement regarding some of the terms, and that would be that the designation of the pickup place and the 3 p.m. Time associated with that, either after school or at the other parent's home if there would be no school. We're requesting that the Calhoun County Standard Holiday Schedule be followed. My client tells me that he enjoyed 4th of July with the minor child, so I believe that perhaps we should pick up on the rotation with the defendant mother having the child with her on the next holiday, which would be the Labor Day weekend, and go forward from that in that manner. I'm not sure what her position is regarding a request to alternate Halloween as a holiday. I know it's not contained within the standard guidelines, but I'd be interested in what her position would be in that regard. Your Honor, Easter, I think that we have an issue with Easter. I think that the defendant would prefer that the day be split. We would concede that the day has been split, and from my client's standpoint, it's a mess. It's too hectic and it does not serve the interests of the child. And we would request that rather than splitting Easter, that it be according to the guidelines, which would be an alteration. In regard to school year versus summer parenting time, my client is in agreement that there be a Thursday overnight during the school year for each parent. In other words, when my client has the child for a week, defendant would get an overnight on Thursday, and the same would apply when the child would be with her mother for the week. One of the issues that we did bring up in the motion, and I don't think we quite have an agreement regarding this, would be taking the child for a deduction for federal and state and local income tax filing purposes. We're asking that it be alternated. I think the defendant agrees that it should be. We have a disagreement in regard to who starts the alternative years. Apparently, the mother has taken the child every year up through 2022. Therefore, we would ask that the rotation begin with the plaintiff father taking the child for the 2023 year. There would be another issue regarding, I think the child's birthday has always been split. Are you okay?
Yeah.
And Mr. Phillips is agreeable to that. And what about the Christmas Eve, Christmas Day?
The birthday, we just want to rotate.
But the Christmas Eve and Christmas Day alternate?
If we can alternate, yes, but we can
Okay,
accept it.
in regard to Christmas Eve, Christmas Day, Your Honor, again, I would concede that the status quo has been that the mother has had Christmas Eve and the father Christmas Day. My client's preference would be that it be according to the guidelines and it be alternated. I think those are the issues as it relates to the motion that we had filed. Oh, I'm sorry, there would be one other issue, and that would be the telephone video contact with the child. We're asking that it be 2 days, be Wednesdays and Fridays. And I think the mother's position is that it should be more frequently than that. But we believe that the 2 days during that 7-day period is appropriate. Thank you.
Okay, thank you. Ms. Henderson?
Thank you, Your Honor. I'm a little bit confused with Mr. Toth's motion because I think we reached an agreement on more issues than he outlined today based on his response to me late last night. We specifically outlined that we are okay with Halloween being alternated with my client having Raylan this year since Mr. Phillips had her last year, and then
That's fine.
Thereafter.
That's fine.
And it was my understanding that was agreed upon. Your Honor, the child is almost 10 and 4 the duration of her lifetime. Mom has always had Christmas Eve. Dad has always had Christmas Day, and they've always split Easter. Those are very important for the child to continue splitting.
Right.
We're not in disagreement with following standard holidays on other issues, with the exception of those 3 major holidays. We would also ask that the non-custodial parent have 3 hours with the minor child on her birthday. Again, this is consistent with what the child is used to and has been used to for almost 10 years. And that is what we outlined in our response. In terms of the other issues that Mr. Toth outlined, we are in agreement with designation of pickup place and 3 p.m. pickup time Thursday overnight during the school year to continue. As it relates to the phone or video contact, again, status quo has been that either party without any issue had the opportunity to initiate contact with the child. That has been in place either through the child's iPad or through the other parent's phone. We do not see any issue with that continuing. Contact has been reasonable. It has not ever been an issue for either party, honestly. So we're a little bit confused with the request being more limited than what has been in place so far, Your Honor. In terms of the tax exemption, we would not object to the alternation. We would ask that the alternation start in 2024. And that is just based on the principles of equity. Mr. Phillips is receiving significant tax-free benefits from the tribe. We would ask that my client be allowed to claim Ray this year for tax year 2023, and then alternate thereafter, Your Honor. I think that answers all of the issues that were brought up by Mr. Toth. Is that correct, Mr. Toth?
I believe so, yes.
Okay.
The
Well, what the court's going to do in this matter, because unfortunately, when the parties can agree and they put the matter to the court has to decide. And unfortunately, that sometimes varies, oftentimes varies from what the parties wish to have happen or have combination of what's happened. Obviously, the parties have agreed that the pickup would be at 3 o'clock on the Mondays. That we would do a standard, the old Calhoun County in front of the court standard where we alternate the holidays. The court would alternate it because the plaintiff had 4th of July, that the defendant would have Labor Day this year, and then alternating dates thereafter. The parties want to recognize Halloween as another date and have agreed to do so. That's fine. They have a right to agree to that. The court will include that as an alternate as well. Parties have agreed that during the school year that the parties would do a Thursday overnight, and the court has no difficulties with that, and that they would have agreed that they would continue to split the child's birthday in a manner they had before, as well as agreed to alternate the tax deduction. It does appear that, again, that the defendant had the tax deduction for the past year. So the court is going to order that the plaintiff would get the tax deduction the year 2023 and then alternate each year thereafter. The court would, as a result, also because the court is ordering the old standard holiday time, would alternate that. I'm not going to make an exception for what the parties had previously done on Christmas Eve or Christmas Day. We would simply alternate those each year, and where they fall, they fall. With that, I think that takes care of Mr. Toth's motion. Ms. Henderson, your motion on counseling.
Thank you, Your Honor. May I please ask one question regarding Easter? Since parties always split Easter, would the court consider giving one party the Saturday before Easter and then the other party the Easter holiday and then
Nope, we're
switching
going to let that. We're going to let that fall where the alternating holidays occur.
Okay, thank you. In terms of our motion for counseling, Your Honor, it is perplexing to my client why Mr. Phillips so vehemently objects to the child being enrolled in counseling. That matter has been brought up first in May of 2023, both to Mr. Phillips by my client and by myself to Mr. Toth. We outlined the reasons for that counseling that were brought up by the child to my client and discussed with her. Specifically, the child is having some issues adjusting between the two homes, different parenting styles. My client outlined such issues as having trouble with staying focused on a task, staying in a seat. Mr. Toth is responding that this is just her pretense of switching schools. That is absolutely not the case, Your Honor. My client is seeking a way for the child to have a neutral third party to speak with, discuss any feelings that she may have in terms of issues in either home or any issues that a preteen girl may have. Your Honor, we believe it's important for her to have that neutral outlet and be able to discuss her feelings freely with either parent, and if not possible, then with a neutral third party that would not judge her. We are asking that the court allow Ms. Fletcher to enroll the child. Mr. Toth responded that tribal benefits should be utilized if possible. We are not at all in disagreement with that. Essentially, my client is seeking for the child to be enrolled in counseling. If it's a tribal counselor, well, we're fine with that. The only reason that Comforts of Home was selected, that is something that the child's doctor recommended, and they were readily available to take her on, Your Honor. So we're asking that my client be allowed to enroll the child in counseling. I'm assuming the parties may be invited into such counseling if necessary and deemed appropriate by the counselor. And I would ask that the parties respectfully follow any recommendations expressed by the counselor. And if the counselor after a couple of sessions says, you know what, she's completely fine and doesn't need to see me anymore until some other issues arise, we're exactly fine with that as well. Again, Your Honor, we're just asking for the child to be able to express those feelings and discuss those emotions that she has associated with going between two households and two different parenting styles, some issues with focusing, some issues with staying on task, and having some fears with a neutral third party, Your Honor. Thank you.
Okay, thank you. Mr. Toth, I did review your answer in this particular matter, and you're basically questioning whether counseling is appropriate, but do you have any opposition with Ms. Henderson stating that if it was a tribal counselor that that would be agreeable to?
Your Honor, Ms. Henderson and I have attempted to resolve this issue, and I think where we're at, Your Honor, is that my client doesn't have the same observations regarding the conditions that the defendant observes. However, the fact that we've been in court twice in less than a year over these child-related issues, my client is agreeable that there be counseling initiated. He has tribal benefits. It sounds like there's an agreement that we would use those benefits to arrange for the counseling. And I think it's important, Your Honor, that the parties are the ones who enroll, if you will, the child, not just the defendant. And I think it's important that both parties be involved to the extent that it's deemed appropriate by the therapist, and that we have a clear understanding of the purpose. It's not to go in and say, Raylan has problems X, Y, or Z. It's that we have a co-parenting situation and the child may be uncomfortable with that. In other words, there's been no diagnoses that I'm aware of to support the claims of the defendant. On the other hand, my client's comfortable with the therapy. If it's going to be helpful to his daughter, that'd be great. So if the order would provide that both parties be involved to the extent deemed appropriate by the therapist, that both parties are involved in the enrollment process, and that the tribal benefits be used with counseling arranged through the tribe, then he has no problem with it, Your Honor.
Okay, thank you. Well, it does sound like the child going through it. It does appear to be normal child reaction to divorce and the again, two households, et cetera. But it does appear that parties are agreeable, as Mr. Toth outlined, that they can participate in getting the child into the counselor through the utilization of the tribal benefits. So I'll kind of leave that to you, Mr. Toth, to put that in the order concerning your motion, put it in as you've outlined as well, that the parties would participate and utilize those particular benefits. And we'll leave it up to the council to make a recommendation at some point, whether they believe it appropriate to discontinue that. The court doesn't like in these instances where we simply keep children in a perpetual counseling scenario. So if in fact it's a matter where the child just has to deal with a few matters and we can get that resolved and conclude, that's what the court would I guess recommend in this particular matter, but we'll wait and see and get a report from the counselor, and then we can again reassess it at that particular time. So,
Very good. I will include that provision in the order that I prepare. I think
okay.
that's the most efficient way to handle it. Thank you.
Okay.
Mike, do you want to just send the order and we'll just do it as a consent one?
That's my intent, yes.
Perfect. Okay.
Court will end this matter at 9:17 a.m. You're free to go. Have a good day.
Thank you.
Erica Roush versus Curtis Voigtnott.
Court will note the appearance of Ms. Reed on behalf of the plaintiff, Ms. Sharp on behalf of defendant. This matter is before the court on the defendant's amended motion for reunification counseling. Ms. Sharp.
Thank you. Ms. Reed and I have been speaking, and I believe that we have some kind of resolution in the sense of this motion. There has been a lot of issues with, I guess this dragging out. And so I believe that the parties have, and then Ms. Reed can correct me, but I believe the parties have agreed to asking the court that friend of the court do a status review of this in 3 months to see the progress that's going on. That the parties continue with Margaret Hunter as the reunification counselor. My client get into individual counseling, and that at the counselor's discretion, he will do a psychological, at the counselor's discretion, it will be determined if he needs to do a psychological evaluation and any kind of DV program. And that with the reunification counseling, it will continue. Margaret Hunter will, start some kind of reunification between the child and dad as soon as a release is signed and she feels that it is the appropriate time. Thank you.
Okay, Ms. Reed, is that your understanding of the agreement?
There's one correction I'd like to make, and that is in regard to the DV program. It's the individual counselor will not determine the appropriateness of the DV program in terms of whether he should do that, but will help him connect with a program, which is part of both this order and his probation order. And I guess, Judge, I did not get a chance to speak with Ms. Rouch. Erica, have you had a chance to listen to that? It really, the goal is again, getting a status review and getting individual counseling started. Would that agreement that Ms. Sharp recited be something you want to agree to, or do we want to have the court hear things out today? Erica?
It sounds like it's what we talked about.
Okay. It's not much of a deviation from everything we've talked about. So I think the big change is it gets it in front of a referee in a few months to see how things are going. So.
Well, why don't we do this? I don't want to just send the matter to the referee. Why don't we set a status conference after the 90 days? We can have it back before the court, and then we'll determine what we're going to do at that particular time.
Thank you, Your Honor.
Okay.
That should be fine. Thank you.
Yep. Ms. Sharp, I'll have you, because it's your motion. You can prepare the order and submit it to Ms. Reed for her approval.
Thank you.
Okay,
Thank you.
thank you.
Megan Phelps versus Dusty Vasquez.
Court will note the appearance of Mr. Vanderhorst on behalf of the defendant. This matter is before the court on the defendant's motion to show cause. Mr. Vanderhorst.
Thank you, Your Honor. Good morning, Your Honor. Good morning,
Yeah.
Dusty. Nice to see you there. Nice to meet you. My client filed through my son, John, a motion for show cause. There's a September 2018 order in place that was consented to awarding joint legal and alternating weekends to my client from 6:30 on Fridays till 6:30 on Sundays on an alternating rotation. That has not been followed since approximately October of last year, Your Honor. My client has continuously attempted to have parenting time. They have a 9-year-old daughter between the two of them. Madison is her name. And my client wants to enforce that order, Your Honor. That order has not been, a motion that we filed has not been responded to. And there's no reason why the parenting time shouldn't continue it as ordered. Also, my client is going on a trip, a family trip. He's married and has 2 other boys. So Madison has 2 brothers, two half brothers that she hasn't seen in quite some time too. But they're planning and got a trip planned to Disney, I believe, World in Florida, October 11 through October 15. That my client would like, we were going to ask for that too as well today, Your Honor, that he'd be allowed to take her with him to Florida for a family trip. I'd like to find the plaintiff in contempt, have her follow the court order. Wish she was here to hear this, so my client can continue to exercise his parenting time. And that's what we're asking for, Your Honor.
Okay,
It's not
thank
really
you.
asking for makeup time at this point in time, but he just wants her to follow the order.
Okay. Well, the fact that she has not appeared here now, the court will note it is now 9:25 in this matter, that the matter was set for 9 o'clock. She's not appeared, nor has she filed a responsive pleading in this matter. The court will hold her to be in contempt of court. The court will expand that order to provide that, again, the court would order that the parenting time would commence immediately in this matter. And the court would order that your client would be entitled to have the child the December or October 11 through the 15th for a trip to Disney World, to Florida, to Disney World. And are you asking for fees as well, Mr. Vanderhorst?
I didn't see that pled, but whatever the court's custom is, I know my client's a hardworking individual, would appreciate anything the court would award.
Well, the court would award you the attorney fees and costs for the motion today. Do you know what that amount is?
Well, my time was about an hour to prepare for today. I don't know what John had into it, but
Well, I wouldn't grant that. I just
Yeah.
grant your attorney fees and costs, Mr. Vanderhorst.
okay, Your Honor. I charge $300 an hour, so it's an hour's time.
Okay, court would allow the sum of $320, being the $20 being the motion fee. The court would order that would be paid within 45 days of today's date. You can include that in the order, and that will conclude this matter at 9:26 a.m. You're free to go. Have a good day.
Thank you, Your Honor. Thank you, Dusty.
Thank you.
And Barbara Miller versus Curtis Miller.
Court would note the appearance of Ms. Sharp on behalf of the plaintiff, Mr. Todd on behalf of the defendant. This matter is before the court on a show cause motion for failing to comply with the judgment of divorce. Go ahead, Ms. Sharp.
Thank you. Your Honor, I believe that we saw, there was pictures attached to Mr. Miller's answer to this motion, but since the actual judgment of divorce, at the time that we actually agreed upon this, Mr. Miller was living still in the same housing, or at least, what he stated that he was living in at that time. There had not been any kind of, change at that point. The child was still residing as from my understanding, exactly the way that he has pled in this motion. In addition, my client has personal knowledge that often the child goes to his friend's house where she has to sleep on a bed. A sofa with her father during his parenting time. And my client still believes he's in violation of the court order by trying to exercise the week on, week off parenting time until he actually, is not, I believe, not staying in the same bedroom, same location, that the child have her own actual bedroom, and living arrangement has changed for Mr. Miller.
Well, Ms. Sharp and Mr. Todd's answer states the child does have her own room and own bed, et cetera. So what is the issue if that's the case?
Your Honor, again, my clients, it just has personal knowledge that this is actually not a true statement. I understand that there is, pictures, but again, my client has personal knowledge that this isn't a true statement. That is her problem, Your Honor.
Okay. Mr. Todd?
Thank you, Your Honor. Your Honor, I think part of the confusion might be that my client has had this living arrangement since mediation. At mediation, there was a statement that the child would need her own room in order for him to exercise the week on, week off. And he said, well, I've already got that, so that's fine. And so that might be the confusion. But the child does have her own room. It is accurate that Mr. Miller does live with the grandfather or with the grandmother, I apologize. But it's a 3-bedroom home. There is a bunk bed, but the child in the child's room, but only the child resides in that room. The child's always had a bunk bed and she kind of prefers that. And that's why we attached the pictures. There are 3 pictures of 3 separate bedrooms and a picture of the exterior of the house. It's a 3-bedroom house. We believe that this could not be more clear. And so we believe he's entitled to his week on, week off parenting time. And we believe actually that the plaintiff violated the order by not allowing that. There's nothing in the judgment which states that he needs to get some other type of court order or anything of that nature. It says that once that is secured, that week on, week off parenting time shall occur. So we're requesting that the motion be denied in total, that he be given a week of makeup parenting time at his discretion. We are requesting attorney fees as we believe it's evident that he has that room and he's told the opposing party this.
Okay, thank you. Any response, Ms. Sharp?
Your Honor, I would just state that at the time of mediation, obviously the living arrangements were similar, but it was kind of inferred that this provision that he would make some changes. So that is why my client's confused. And also that he was not requesting week on, week off until the time where my client filed this motion. So she did not have any idea that there's any kind of change, and also that there wasn't, I don't know why it wasn't inferred at the time of mediation, that this provision even needed to be in place since he already had it. Thank you.
Okay. Mr. Todd, when did obviously the summer provides for the alternating weeks. So when do they alternate on Friday, Saturday, another day?
Your Honor, I believe that they would alternate on Friday. And I believe that his weekend should have commenced approximately June 9th.
Okay. Well, what the court's going to do is the judgment does provide that when the defendant secures proper living arrangements, that parenting time would commence. It sounds, based upon what's stated, that he does have proper living arrangements with the pictures, et cetera. The court will grant that in order that the alternating weeks take place commencing this coming Friday. The court would allow the plaintiff to, on this Friday, she can drop the child off for the parenting time. She can inspect the child's bedroom if she wishes to do so. And the court will reserve on makeup parenting time and on the attorney fees in this particular matter. So, Ms. Sharp, as you had commenced this matter, the court would order that you would prepare that order consistent with that. You can send it to Mr. Todd for approval or submit it under 7-day notice of entry.
Thank you, Your Honor.
Okay, thank you.
Thank you, Your Honor.
We'll end at 9:37 a.m. You're free to go. Have a good day.
Thank you, Your Honor.
Court would note the appearance of Ms. McNiff on behalf of plaintiff, Mr. Bartell on behalf of defendant. This matter is before the court on the plaintiff's notice for entry of order and the defendant's objection. Ms. McNiff, after receiving Mr. Bartell's objection, have you recalculated the overnights, as he's saying, it should be 110 rather than the amount that you had calculated the support on.
Your Honor, Mr. Bartel was correct about that. When I calculated child support, I did miss that additional Sunday evening, so his child support order is correct. I think the only issue we have at this point is whether or not there's joint legal custody or sole legal custody. And I would take issue with Mr. Bartel's characterization that our motion didn't address those issues. We asked for sole legal custody, and we gave reasons why, such as the fact that defendant has not been involved with the children's medical appointments, with taking them or picking them up for school or being involved in their school activities, that he hasn't participated during the marriage in those kinds of decisions that would incline him to joint legal custody. So we would ask that that be maintained as sole.
Okay, Mr. Bartel?
Your Honor, and obviously it's whatever this court really meant by it. And there was the transcript. The court did order sole custody to plaintiff. We took that to mean physical custody because the main thrust of the arguments at the last hearing was regarding parenting time and such, and not really regarding legal custody. I mean, legal custody is pretty standard. This court did give my client 110 overnights. I don't think there's really anything there that should prohibit him from being able to participate in the major decisions regarding the minor children. So I think it should be the joint legal custody.
Well, in this particular matter, a court would state that when I state that I'm granting custody to a party, if I don't delineate a difference between legal and physical, then I mean basically complete custody, which would be legal and physical. That was the intent, at least of the court in this matter. So, Ms. McNeff, I'll simply ask that you would make sure, I think your order probably states that it's for the sole legal and sole physical, but also incorporate Mr. Bartel's support calculation and then resubmit that under 7-day.
We can do that. Thank you, Your Honor.
Thank you.
All right, thank you.
Court will end this matter at 9:40 a.m. You're free to go. Have a good day.
When I had met the plaintiff, she was already pregnant, and she kept his real father out of his life for about 2 years. I just don't feel it necessary for me to have to pay support when his real father is seeing him consistently. And as far as me signing the birth certificate,